The origin of these webinars is that I wanted, when I was starting out my arbitration practice, I was looking for practical advice and resources, and I've now created what I hoped I would have when I first started out. For those of you who don't know me, I'm a partner at Learners, and I'm an arbitrator at Arbitration Place. I'm also the editor and writer of the blog Arbitration Matters, which summarizes cases as they are released from courts across Canada and includes commentary on the significance of those cases to arbitration practice. You can subscribe for free to get copies of those cases and analysis once a month, or of course you can just access them on the website. There's over 900 cases at this point, so a good research tool. After this session, you will get a recording of this session. You'll get a list of the various resources that I talk about, and I'll send you a list of the previous webinars. So today I've got the Q&A box open right now. You can start sending me questions whenever you wish. I will leave some time at the end for questions at the end if we have time. So the topic today is procedural order number 1, bedrock of the arbitration. And I believe it is the most important document, apart, of course, from the final merits award in the arbitration. It is a big deal. It is important because it sets out the procedure in the arbitration that takes the parties to the merits determination. It sets out what evidence will be adduced, in what format, and it sets out a timeline to the final hearing and all of the steps along the way. And the objective is that all of these steps are built in with some wiggle room so that the hearing date is not at risk of being lost. Sometimes it also contains important substantive issues like whether there's a jurisdiction issue that needs to be determined very early on before anything else proceeds in the arbitration. So this session is a good companion to the one I did in session 4 in January of 2023 about the first procedural conference. And that is the conference which precedes procedural order number 1. It identifies all of the issues that should be addressed at the first procedural conference and the significance to those involved. So, for example, the arbitrator's role at the first procedural meeting is to identify the agenda items for discussion. And of course, the parties will likely and are free to add to that agenda list. And that agenda often comes from the pleadings if they've been exchanged already, the arbitration clause, and perhaps information that was learned at a preliminary meeting. And I will talk about that preliminary meeting, which is pre-procedural conference number 1, in a moment. Counsel at the first procedural meeting, their role is to consult with their clients and opposing counsel to allow them to come prepared to the first procedural meeting so that they are ready to set deadlines and to flesh out procedural order number 1, because an order, procedural meeting number 1, because an order will be made at that procedure. So before we start talking about actually what goes in procedural number 1 and its purpose, for those of you who are not that familiar with arbitration, let me give you some context about what the arbitration often looks like, and this will help you understand what it is that we're going to be doing at procedural number 1, procedural meeting number 1. So do not assume that the procedure that will be used for the arbitration is the same as the court process, except faster. The processes are often very different, and the most significant of those, which counsel who haven't done a lot of arbitration often find surprising, is that there is not the broad production obligation that we see in civil litigation. There's often production only of reliance documents. Each party produces the documents upon which it relies and then has an opportunity to request additional documents from the opposing party. So that's the first major difference. The second major difference is what we call in litigation discovery, but what we call in arbitration pre-hearing examinations. And they are very rare in arbitration because of the way the evidence is structured. And what we often call that is evidence first arbitration. And if you'd like to know a little bit more about that process, there's excellent paper by William Horton on his website, which I will send to you in my resources, which talks about what evidence-first arbitration is and why it can get you to the arbitration hearing and a final award much more quickly than litigation can, without sacrificing any of the procedural safeguards. So what procedural first evidence-first arbitration allows is a lot of flexibility so that the procedure is customized for each dispute. It has been used successfully in international arbitration and imported into. Somebody's got their doesn't have their mute on, and I can hear some background noise. The process involves submitting the affidavits of evidence that will be relied upon for the hearing very, very early on, so that the necessity for broad production and pre-hearing examinations is almost always eliminated. This was a process that originally started and was very successful in international arbitrations and has been imported into domestic arbitration because it is a process that allows for resolution of disputes, no matter how large the document set, no matter how complex the issues, no matter how many parties. And so the real benefit of arbitration is getting to the end result in a way that is much more efficient, again, without sacrificing parties' rights. And so that is the process that is going to be discussed at the first procedural meeting. Each case has a customized procedure, which is what is fleshed out at the first procedural meeting. So while the parties may have had some discussions about procedure and the arbitrator may have had some preliminary thoughts about it, the procedure actually gets finalized and nailed down at the first procedural meeting. So what do I do as arbitrator to prepare for the first procedural meeting so that I'm in a position to make the first procedural order? I usually start with a preliminary meeting, which is before the first procedural conference. And not everybody does this, but I find it very useful because before I'm appointed even, I find it useful to speak to counsel to find out where they are. Have they had discussions about some of the issues, the procedural issues that are going to arise, including things like dates for hearings, whether the parties have agreed on rules of procedure, that sort of thing. That then allows me to prepare an agenda and the parties to contribute to that agenda so that we are ready for the first procedural meeting and all of those issues can be addressed without having to adjourn it, which becomes, of course, difficult with parties and counsels and arbitrators' schedules. So things like who are the proper parties? What are the hot issues that the parties have identified that they'll need to address? One of the most significant usually is whether one party has sufficient documents in order to really to go any further in preparing for the arbitration and indeed in preparing for the affidavits. There are also issues discussed sometimes about my terms of appointment. And so those are the issues that are addressed very early on. They allow the parties to go back, counsel to go back and talk about things that emerged at that preliminary meeting so that they're prepared to get instructions and have them addressed at the first procedural conference. The arbitrator must be appointed before the first procedural conference because otherwise the arbitrator does not have jurisdiction to make any order. And so that's one of the reasons why I feel and find having a preliminary meeting extremely useful. Sometimes it identifies issues that counsel haven't even thought of. And so it assists in everybody being much more prepared for the first procedural conference because the objective is to start with setting the hearing dates and work backwards with a schedule that works and hold those dates, hearing dates, firm. The issue used to be whether the procedural conference would be in hearing or on Zoom. It is almost entirely on Zoom these days, and my experience is that those meetings should be about an hour and a half to 2 hours. That amount of time needs to be set aside. There's a lot to talk about. What do I do to help the parties prepare, and how do I prepare? First of all, I read what's necessary. obviously. Usually that's the pleadings if they've already been exchanged. And the other issue is the arbitration clause. There are sometimes issues that arise in the arbitration clause that need discussing. The preliminary discussions include what is the case about, what do the parties contemplate in the way of a process. The arbitration agreement itself often creates issues that need to be discussed. So there are sometimes inconsistencies in the arbitration agreement. For example, is it clear that the parties are to arbitrate, or is there some jurisdiction left for a court? Those issues should be addressed so that both parties are on the same side on those issues. Sometimes there are issues where it's absolutely clear the parties are not on the same side, and then those issues will be addressed in the arbitration, and they'll be added to the list of things that go into the procedural order number 1. Sometimes the parties have reached agreement on the process already, and unless it's an agreement as to procedural rules, it's often a discussion that takes some time, because the parties may not have thought of everything that I think is important. And so it's sometimes an evolving discussion. If the parties have reached an agreement and they're not prepared to deviate from it, the arbitrator does not have any jurisdiction to make an order that is not consistent with the parties' agreement. But usually it's the case that the parties have kind of mapped out a process. And then as we talk about the various issues that need to be included in the order to get us to a final hearing, there is some adjustment. So it's often a very collaborative process. And for that reason, it's often helpful to have parties present at the procedural meeting so that they can provide instructions to their counsel on timing and that sort of thing. Before the procedural conference, I usually send to counsel an agenda of the items and ask them if there's have anything that they need to add. Often, as a result of the preliminary meeting, there are issues that get added to the agenda that need to be resolved at the first procedural meeting. And some arbitrators will actually prepare and send a draft procedural order. And there is such an order, which I think is an excellent one. It's a schedule to the new ADRIC arbitration rules, which you can find on the ADR Institute of Canada website. And Appendix R3 contains a draft procedural order that can serve as the template, and it can be adjusted to suit the specific dispute. I often find that parties aren't ready for that, and so I usually circulate an agenda, but there are many arbitrators who do otherwise. It's expected that at the first procedural meeting, parties will be ready to talk about all the issues that need to be addressed procedurally and often substantively, and set timelines, which means they need to have advance notice in my agenda of the issues that will be discussed so that they can get instructions. And they need to have the calendars of their clients, potentially witnesses whom they intend to call, and of course their own counsel team. So that is pre-procedural, first procedural meeting. Let's dive right into the procedural order itself, which results from procedural meeting number 1. What is the purpose, the overall purpose of procedural order number 1? First of all, it is clear that it is to set a timetable, but it has other purposes as well. First of all, it instills a discipline in the process. It avoids the kind of heel dragging and slippage that invariably results in civil litigation as a result of busy counsel schedules, difficulties in getting court time. Because the schedule is set from the very beginning through to the hearing, everybody understands what needs to be done when, and they're disciplined to achieve those milestones. The schedule also will contemplate issues that may not yet have arisen. So it has some wiggle room, as I say. So it may be that at the moment the parties don't contemplate certain disputes, for example, relating to documents. But as the process unfolds, one of the parties realizes that it needs access to documents that it doesn't yet have. There becomes a dispute over whether those documents should be produced, and that dispute is something that needs to be resolved by me. So including time in the timetable, whether you need it or not, helps ensure that the final hearing dates do not get disturbed. And that is, in my view, my objective as the arbitrator, to make sure that the deadline that has been set, which the parties have agreed to and committed to, does not get set aside or adjourned. It requires the parties to think at the front end about all of the issues that may arise so that we can schedule time if they are needed. And it's very common that those dates come and go, and there's no need for time for ruling from me, but at least it's there. And it's not uncommon that parties haven't thought through that completely. So one of the purposes of the discussion in procedural meeting number 1 is to talk about the potentials for disputes on the various issues and steps in the process. The third purpose of the first procedural order is to set the ground rules and expectations of the parties. And invariably, my order will say that there are no changes to any of the deadlines except on consent or by my order. And the same goes for the final hearing dates. If extraordinary and unforeseen circumstances arise or the parties agree to change the dates, those dates may change. But otherwise, everybody understands that once the schedule is set, it does not vary. And that's one of the benefits of arbitration, that the parties agree to a schedule or it's imposed by me after submissions of the parties, and they appreciate that they have to make it happen. And because they've been consulted on timing and schedules, there is no reason, absent unforeseeable circumstances, why the timeline and the dates for the final hearing need to be changed. So what is the relevance of procedural order number 1 to procedural rights and to fairness rights? This is absolutely critical because all domestic and international arbitration legislation in Canada include fairness rights. And those rights are that the parties shall be treated equally and fairly, and that each party shall be given an opportunity to present its case and to respond to the other side's case. This includes the hearing itself and at procedural conferences. And so it's absolutely necessary that parties, counsel be provided with an opportunity to make submissions on all of the issues that arise, not just at the hearing, but also at the procedural conferences. It's a dialogue back and forth, after which the arbitrator will make a decision. In reality, it's often a collaborative process, and it's more uncommon than not that the arbitrator will make an order which is inconsistent with the submissions or the representations or wishes of any of the parties. It's usually a consensus-based approach. I always give counsel an opportunity to review the draft procedural order that I've made following procedural meeting number 1. It's possible that I haven't entirely understood what the parties were requesting. It's possible that they haven't entirely understood the consequences or the language of the order that I made. And this is another protection to both the parties and to the arbitration, so that we don't later hear that one of the party is seeking to set aside an order on the basis that there was some unfairness, or that the party didn't have an opportunity to take a look at the process that was set out in the procedural order and make changes to it if there were some objections. The failure to ensure that these rights are protected can give rise to a set-aside application by one party on the basis, or both, on the basis that the procedure itself was unfair. And procedural order number 1 is absolutely essential in recording the process and the submissions of the parties, and to ensure that if there is a court that is ever looking at the process because of an application to set aside, there is some contemporaneous record, which is the arbitrator's order, that will assist the court in understanding what occurred and determining whether the parties were fairly treated. The procedural orders as many of them as they are throughout the arbitration, are often the foundation for the procedural history portion of the final award on the merits. And the procedural history is extremely important so that if there is a reviewing court, either by way of an appeal or by set aside, that reviewing court understands the history of the matter. And that will be things like when the parties entered into agreement, when there was a dispute, when the arbitration was started, when the first procedural meeting took place, what orders were made in that first procedural meeting, etc. So that it isn't necessary for a reviewing court to go behind the procedural orders to understand what occurred. The procedural order will therefore show how the parties' rights have been protected. So, for example, I will put in my procedural order the fact that I've given the counsel an opportunity to review them and make comments on the procedural orders before I've finally issued them. The other examples are if a party wants oral pre-examinations for discovery, they must advise by such and such a date. If they don't advise by that date, they've waived their right. So no counsel can come back and say, well, I really did want an opportunity for discovery and I didn't have a chance for it. Or if the parties agree that I have jurisdiction, that's something that should be recorded so that you don't end up with a jurisdiction issue later on that could have been foreseen at the very beginning, which can create a big problem, of course, put a monkey wrench in the arbitration, or that the parties waive objection to whatever. So those essential kinds of terms ensure that they don't come back to haunt you later in the arbitration, because parties have been required to commit to a position on these important issues. There's no there's no consensus on how detailed the procedural order must be. So this is all a matter of procedural, what goes on in the procedural meeting and personal arbitrator style. So finally, we're going to get to what goes into procedural order number one. And the answer is that it depends, which won't surprise you because every case is different. So it depends on the parties and the counsel. There are more issues that need to be addressed, for example, when there is an international arbitration and parties come from different legal traditions because they won't necessarily have the same expectations on what the procedure should look like. So those fundamentals are things that will have to be discussed at the first procedural meeting and will have to be recorded then in the procedural order number one. Do they have the same expectations, for example, as to whether there will be pre-hearing examinations? If they don't, that is something that needs to be fleshed out, and it will, of course, be in the agenda that the arbitrator has circulated. It also depends on the arbitrator. Many arbitrators have their own standard procedural orders that contain the terms that they find very useful. And I've told you that there's a good example of that in the ADR Institute of Canada rules, which can be modified, things can be added, things can be taken out. And some arbitrators will focus on different issues and have different comfort level with more or less detail. So there is no standard personal PO number one, but there are lists of the kinds of terms that should go in there to assist both counsel and arbitrators in addressing the issues that are important. What procedural order number one contains also depends on the case. What procedure do the parties want? What procedure makes sense based on the case? Is there urgency? Will one of the parties be seeking interim or emergency measures? What is the volume of evidence that is expected? That will, of course, affect the timing of when it will be adduced and perhaps the number of witnesses that will be called, and that will affect the number of days, hearing dates that need to be scheduled. The speed. Some cases will obviously take longer than others. However, in my experience, regardless of the number of witnesses, the length of the hearing, the complexity of the issues, an arbitration can begin and end within a year, and the limitations usually relate to the schedules of counsel and the parties. But the case and the urgency of the case is absolutely essential because procedural order number one will set out the timeline. The devil, of course, is in the details, and that is why the detailed discussion in the first procedural meeting and in subsequent procedural meetings is absolutely essential to make sure everything is there. Typically, what I include in a first procedural order is the following. So first of all, I try always to start with setting a hearing date. That isn't necessarily where we start in the discussion, but that's where we start when we start actually slotting events into timelines. And I make that clear before the first procedural meeting that that will be an objective and have counsel prepared to address that. There are occasions when that is simply not possible. For example, when there are documents in the hands of third parties that are absolutely essential to the arbitration, and it's necessary to figure out a way to get those documents before there can be real progress in it. But for the most part, that's the expectation. The procedural order in my procedural order normally records issues that are not contentious. So it commits parties to a position or raises issues that need to be addressed at the outset. So for example, what is the law of the contract? Usually you see that in the contract, which includes the arbitration clause. Maybe the parties are entering into arbitration with a submission to arbitration agreement instead. So there needs to be discussion about what the law of the contract is. What is the law of the arbitration or the seat? Is there a jurisdiction objection or are there jurisdiction limitations? Is the arbitration properly constituted? This can arise when there's an arbitration clause that requires, for example, mediation to take place before arbitration is permitted. Has that mediation taken place? Have any of the preconditions to arbitration being satisfied? If not, it may be that we're not in a position to set dates until those preconditions are satisfied, and it may be we can set a timetable for those. Are the proper parties at the table? That can sometimes happen when the parties haven't really, the counsel haven't really thought through who will be necessary to be at the table at the arbitration. Sometimes there's an issue about whether third-party non-signatories should or can be at the table. Those sorts of things should be fleshed out at the first procedural meeting and recorded in the first procedural order. If there are preliminary motions that are contemplated, those should be addressed and recorded as well. I also get parties to talk about procedural rules. I find procedural rules extremely helpful for the parties rather than customized rules that they create because the rules are tested and tried, tested, and true. So when parties have agreed on rules or created their own, it is often useful to have a discussion about them to see if they're going to work for the procedure. So as I said before, the arbitrator does not have jurisdiction where the parties have reached agreement on an issue. However, that doesn't prevent the arbitrator from trying to persuade the parties that perhaps the approach that they've taken may not work for whatever reason in these circumstances. And that is a common discussion as well. And so I often find that if even if counsel have had preliminary discussions about what will go in the timetable and the actual timing, that those get adjusted as we start talking through all of the issues that need to be addressed before we get to the merits hearing. The common rules that the parties agree to, which do not require administration by an institution, are the ADR Institute of Canada arbitration rules, which have just been updated and are effective as of March the 1st of this year, or the IBA rules of taking of evidence in international arbitration, which is often used in domestic arbitration as well. They set out the roadmap, and what kind of document production is to be made and when, that sort of thing. Here are other things that I often raise for discussion. No unauthorized recording of any of the procedural conferences without consent of all of the parties and the arbitrator, and no unauthorized recording of the final hearing as well. We will address that obviously as part of this procedure discussion. Will we have transcripts? Will we have a recording? And if so, how do those get done? No AI. this is something that is now foremost in everybody's mind, and my policy is the same as the courts, which is you have a discussion about AI, and if you're going to use it, it must be disclosed, and there must be consent. Privacy, confidentiality, and security. Those are critical issues in some arbitrations and not so important at others. In others. This is something that must be addressed immediately because there may be special measures required to exchange evidence, to communicate with counsel and the arbitrators, and it may be necessary to have specific provisions about how communications are to be done, whether productions can be made by email or not, whether witnesses are required to make undertakings as to confidentiality, that sort of thing. There are some cases where it's really not important, and that's largely private entities with no public profile. They're mostly content to simply exchange documents and communications by email. Then you get to large public corporations, which have a public interest and are newsworthy. Those corporate parties may have a higher level of interest in security and may require greater measures. And of course, then when you get into involvement of states, that is an entirely different level of security that's necessary. And there are statutory requirements in the seat of the arbitration which deal with privacy and security issues. And so counsel and the arbitrator need to be familiar with those as well. So sometimes that can be a big discussion. The other issue I often address at the outset is transcripts. I like to have transcripts, certainly at the final merits hearing rather than a recording. I find it easier to review the transcript in order to prepare my final award. That's something that often parties want to discuss at the outset. The key, one of the most important things that I like to raise for discussion is the importance of counsel communicating and cooperating with one another, which is something that doesn't happen as often as in litigation as it should. And so I often include in my first procedural order a term that says an issue is not to be raised with me until it has been discussed with the other parties. That's not to say they reach agreement on what the issue is or how it's to be resolved, but they've at least consulted with one another on the issue so that when it comes to me, parties are prepared to address what the issue is and how it should be resolved. It also prevents counsel writing to me about issues that the other side knows nothing about, and of course will then object to. Then, of course, I talk about the timetable, and I've referred to how that gets dealt with. Are there preliminary issues to be decided? Let's schedule those in. When will there be an exchange of documents? What will that exchange look like? Sometimes both parties don't have all the documents, and so that's what I call kind of an asymmetrical case. And so the production of documents may be much more important in some cases than in others, where there are largely negotiations, for example, by exchanges of emails. Most parties have all the documents that are necessary and they can go straight into preparing their evidence or affidavits, but that's not always the case. There may be a first round of production and then additional requests for documents, which may have to be incorporated into the timetable. Those requests are very often in what's called a Redfern schedule format. And that is a chart form in which the documents requested are listed, the reason for that request, the relevance to the proceeding, and the assertion that the other side has those documents and the requesting party doesn't have those documents. Then on that same chart, the party receiving the documents will either agree or object to producing them. And if there are any objections that one of the party requires a ruling on, that chart comes to me. And for the most part, it's not necessary for any other evidence or submissions to be made in order for me to make that ruling. So there are exceptions, of course, and some counsel feel much more comfortable making submissions, but this gives you a sense of how the standard procedure can be modified based on the issues and what's necessary in order for counsel to make the submissions they think are necessary in order to achieve the ruling they're seeking. Then there is invariably a discussion about pre-hearing oral examinations. As I've said earlier, that those counsel who do mostly litigation work think that examinations for discovery are absolutely essential, and they can't imagine a circumstance in which discovery would not be necessary. And my experience is that those counsel, when they appreciate how the process is going to go, and once they've exchanged their affidavit evidence, the reasons for which they wanted examinations for discovery are largely eliminated because they have the other side's evidence and admissions. And those are the two reasons why parties need examinations for discovery. Occasionally, there may be one issue that requires some narrow discovery, and so that can be dealt with in a very short period of time on a very focused issue. These are all ways you move the schedule along in a very efficient way. I often ask the parties if they want a carve out for settlement discussions. Some do, some don't. I never make an order requiring mediation or settlement discussions. I don't think that makes any sense at all. But some parties would like to have a carve out of time where pens are down and they're either engaging in mediation or settlement discussions. And if that's the case, we put that into the procedural order. Then we get to the evidence on the hearing. It is commonly affidavits or sworn witness statements of the fact witnesses and the evidence of the expert witnesses. So let's talk about the fact witnesses first. All of the witnesses that each party intends to rely upon for the hearing must be delivered in this preliminary way in early on in the process, including experts. And again, counsel who do mostly litigation work feel very uncomfortable with this idea because, of course, certainly in the Ontario rules of civil procedure, the expert report is something that's delivered 90 days before trial, in other words, very late in the process. Arbitration, fast forward all of that for the reason that parties want all of the evidence that's going to be relied upon up front, and that's the only way that you can proceed with an efficient process. And it is a well-recognized procedure that ensures that parties' rights are preserved, and the way the expert evidence is dealt with may well be different than in litigation as well. And we see a lot of that in expert protocols. For example, there's a very good expert protocol that the Chartered Institute of Arbitrators has put out. The Chartered Institution of Arbitrators International Arbitration Practice Guideline on Party-Appointed and Tribunal-Appointed Experts. And I will send a link to that after this webinar. And it sets out a very detailed procedure on communications with experts, collecting information, the form and content of the expert reports, and how the evidence may be done in the hearing. I'm sure all of you have heard about a process called hot tubbing, which started in arbitration and is now sometimes used in civil litigation. And it is essentially a process in which the experts testify at the same time so that the tribunal and parties have an opportunity to understand the differences and the similarities between their evidence. And so the process doesn't put the arbitrator in the situation of having to decide between two expert reports, that which can be a very difficult process. So the arbitration expert protocol will often provide ways to allow the experts to communicate with one another to try to reduce the number of issues that are in dispute. So they will often meet with each other in advance and perhaps even prepare a joint report which sets out the agreed facts, the issues they agree with, the issues they don't agree with, their conclusions, how they differ, to provide a guideline to the arbitrator to understand, depending on the factual findings that are made in the legal submissions, it's a roadmap to how the expert evidence is to be interpreted to allow for a determination of the issues that require expert evidence. The arbitration protocols for expert witnesses are so helpful and help cut through a lot of the difficult issues that arise at a normal civil trial. And I think they're very important to consider as counsel at a procedural conference where we start talking about how the expert evidence is going to go in. I always ask counsel to provide the documents that they submit to me, so affidavits, submissions, factums, in both PDF and Word format, bookmarked and hyperlinked. And what that does is it allows me to move through all of the various documents, and in some cases cut and paste for preparing my award. Again, hearing dates. Talk about that. How will the hearing be run? And a number of days. Sometimes that can't be decided until later. So issues that can't be resolved at the first procedural conference will then be deferred to a later procedural conference. And there may be many procedural conferences which follow the first procedural meeting, or there may be only a few. Those further procedural conferences will likely arise after the evidence has been exchanged, because in that process will emerge additional issues. Is there a concern about whether some of the evidence is prejudicial, inadmissible? Are there objections to the expert's qualifications? All of those issues get addressed before the hearing, so that once the parties and the arbitrator attend the merits hearing, we're dealing with the merits. There are no surprises. And one of the advantages of arbitration and the flexible schedule is that there is room that can be made for a resolution of all of these issues, often on a very informal basis, before the hearing. Those issues get resolved in a procedural order, and it may relate to, for example, document production issues, which then gets all of those issues out of the way before the hearing. I will often have a pre-hearing meeting very close to the final hearing, because that is when parties really have a sense of the issues that will have to be dealt with before the merits hearing. So, for example, how are they going to divide their time? Now that they've seen the evidence and they've agreed that the hearing is going to be, say, 5 days, how are they going to divide their time? Are they going to want to have oral or written openings? And if they're going to be oral openings, how much time is necessary? Who's going to take that much time? Where there's who's going to be examined first? The amount of time for examination in chief, which is usually very short, because the affidavits of each of the witnesses is the examination in chief, but there's time, of course, for cross-examination, and the counsel have a lot of time to prepare for that because they've had the affidavits in advance. So I usually ask the parties to create a full schedule about cross-examination time, and rather than, for example, use a chess clock process, which I know is common in international proceedings, and that is each party has a certain amount of time to put in its case, and they can divide up their case as they see fit. But there is a chess clock timer on to make sure that each party gets exactly the same amount of time. Once we talk about the hearing schedule and preparing for the hearing, there's often a discussion at the pre-hearing conference about a joint list of issues or agreed statements of fact. As counsel in litigation proceedings, I always found those really difficult, and I never really found agreed statements of fact all that helpful because they take so much time. However, I find in arbitration, because the parties have so much communication with one another, and because all of the sticky issues are dealt with before the hearing, they're often a very good position to agree on a statement of facts, which is extremely helpful for the arbitrator because that just gets plugged into the facts section of the award. And of course, where there are contentious issues, those will have to be decided by the arbitrator, but often the background facts can go quite helpfully and easily in an agreed statement of facts. I always ask for a joint list of issues. The most important thing that arbitrators must remember is that they have limited jurisdiction, and that jurisdiction is limited to the issues that the parties have put to them. So it is extremely helpful for the arbitrator to understand exactly what it is that the parties are asking them to do. And I've never had any difficulty with parties not agreeing on what the issues are. They may disagree on how the issues are to be resolved, but invariably they agree on the issues that divide them. There will be a discussion about openings and closings. Again, are they oral? Are they in writing? Are they before the hearing? The openings are usually at the outset of the hearing, obviously. At the closings are often at a later date. If that's what parties want, that should be put into the schedule as well. And there are strategic issues about whether you want to do closings right after the hearing ends or later on. And that includes cost submissions as well. If you do them right after the hearing, you don't know the result of the award, but it's much more efficient because you don't have to have further delay, sometimes months or weeks while the final submissions are made and the cost submissions are made. The downside, of course, is that you don't know the result. So it's a really important discussion to have very early on about what the parties would like to do as to timing, because that obviously affects their preparation. I'm going to refer to some other issues that often come up in procedural orders, but not in my practice, because I think they relate more to circumstances in which the parties come from different places. And so they may not have the same expectations about the way that the arbitration should run. So there are issues, for example, about communications. How are parties to communicate with one another? Is email sufficient to give notice? What about service? What does service look like? When is service necessary? And this may arise, for example, when there's a party who is non-participating. And how do we ensure that that party gets notice throughout the process? How are communications made to the tribunal, to the various parties? What is the effective date of receipt? Most times when I deal with counsel from Canadian provinces, we all have the same understanding about what that looks like, and it's not necessary to have a discussion about that specifically unless they want to do something different. Deadlines, time limits. I usually put in my procedural order that the deadline means documents need to be sent or delivered or served by 5 p.m. on the day, the delivery date, so that the other side isn't getting material at midnight or something like that. But those issues become very important when you're dealing with different time zones. So that'll be something that's important to discuss. Translation. You've got documents and perhaps witnesses coming from different places in the world or having different language preferences. And how does that get dealt with at the hearing? What kind of transcription do you want of documents? Is it by a person? Is it AI generated? What if there's a dispute about the accuracy of a translation? Those sorts of things should at least be discussed. An electronic document management system. This rarely becomes an issue any longer because parties and counsel are very sophisticated in using the technology, and they often use something very similar. So there isn't real issues about an exchange of documents in a format that another party can read. But if you're doing something unusual, it's a good idea to discuss that at the time. A remote hearing protocol. Again, I rarely have a discussion about this because we're either dealing with a Zoom call with some of the protections that are there to ensure that everybody's in the same room, for example, or there are breakout rooms available, that sort of thing. But there are remote hearing protocols that were generated by the ICC, for example, the Chartered Institute around COVID when people were trying to feel their way around what the process would look like. And but I think that the way Zoom calls are going now, whether they be procedural meetings or hearings, are quite smooth. So generally, it's not necessary to discuss that. But I do sometimes find there needs to be a discussion about who's going to be in the Zoom call, the hearing room. Witness statements, formatting. Some jurisdictions require a photograph of the witness. So understanding the requirements of the jurisdictions in which all of the parties come. Whether there's going to be a tribunal expert, which is very uncommon, as opposed to experts who are appointed by each of the parties. And the timing of the award, that's something that needs to be dealt with very early on. And in fact, if the parties have agreed that the award will be delivered, say 3 months after the end of the hearing, The arbitrator must know that before he or she is appointed, because if he or she cannot meet that deadline, then they must decline the appointment. So I've talked all about purpose of procedural order number one, what goes into it, strategical and practical considerations. What about procedural order number two and following? And those, of course, take place after subsequent procedural hearings. And they may arise because, as I said, there's disputes about documents. There may be need for evidence from someone who is not a party, who has not sworn an affidavit, or is not cooperative. Those sorts of things will have to be addressed as they arise so that we don't have delays in the hearing. And there will, in my view, those potential issues are mostly foreseeable and should be dealt with in procedural order number one, but if they arise later, they will be dealt with in subsequent procedural orders, and those procedural conferences to address those can be raised at any time. So it's not uncommon in the way I do arbitration, which I view as kind of case management, that if an unforeseen issue arises among the parties, I get an email, a joint email saying, this is an issue, we need your guidance or a ruling on this. And we book something that is not within the timetable, but ensures that the other deadlines don't get disturbed, which is why you need to build in a little bit of time between the dates and of the other issues. But it requires a commitment on the part of both counsel and the arbitrator to make sure that they prioritize the arbitration so that these issues can be dealt with as they arise and don't end up causing delays or a lengthening of the hearing dates. The subsequent procedural conferences will talk more about venue issue, costs, travel, tech requirements, who will be attending, whether there will be a witness exclusion order, are there any accommodations required for people, how to deal with exhibits. Are they going to be entered as exhibits? Is there a joint document brief? Are they going to be referred to tab number in the affidavits? How to deal with evidence that a party may want to adduce that goes beyond the affidavits. And what that usually raises is how witnesses will be impeached. It's not uncommon that it will occur to counsel once they're starting to prepare their cross-examinations that they would like to use a document that is not attached to an affidavit for impeachment purposes, and that will come up closer to the hearing date. Then after the hearing, before the final award has been rendered, there may be a procedural conference to talk about dates for final argument. Are there going to be page numbers, any other limitations, costs arguments, that sort of thing. And there may be more than one award that gets issued. So there may be a merits award, and then there may be a costs award. And the arbitrator maintains jurisdiction so long as they're not functus. So one of the common practice and a wise practice is after delivery of the merits award, if there is going to be a separate cost award, that the arbitrator makes it very clear that they're reserving jurisdiction to allow that cost award. And of course, the cost issue, how it will be briefed, when those submissions will take place, whether there's simultaneous exchange, all of those sorts of things come up in subsequent procedural meetings. Now, I've alluded to the fact that sometimes there are difficult issues that can come up in conferences. So once again, where the parties come from different legal traditions. It may be that each counsel cannot make assumptions and the arbitrator cannot make assumptions about how the process is going to go, what the evidence is going to look like, what timeline works. And so this requires a very different way to think about the process and often involves a greater conversation among the parties. And what the arbitrator absolutely must do is make sure that there is an even playing field. For example, there are some jurisdictions in which counsel have professional obligations that prevent them from preparing witnesses or helping their affiants swear affidavits, prepare their affidavits for being sworn. You can imagine what a disadvantage that would put a party whose counsel is subject to those professional responsibility restrictions compared to the party whose counsel is allowed to sit down with them and prepare their evidence. Those issues need to come up very early on. They need to be flagged and they need to be addressed. And so you can see that there are a number of issues that could very well arise in international arbitrations that simply don't come on the radar for domestic arbitrations. The other issue that often comes up is counsel have very different experiences with commercial arbitration. They largely practice in the courts, and so they're not prepared for the kind of flexibility or the kind of case management that arbitration offers. And so they may come prepared to the first procedural meeting with an expectation that what they're going to be doing is setting a timetable under the rules of court, but in a compressed time frame. And that, of course, is one scenario, but there are other scenarios in which parties counsel don't have a full appreciation of the way many arbitrations are run in order to ensure efficiency. And so what I will do sometimes is I'll appreciate that at the preliminary meeting, and I will circulate to the parties, for example, some institutional rules that may assist them in understanding a process that might work, and the William Horton article that I've just referred to on evidence first arbitration. So they appreciate the pros and the cons of this kind of a process, and they're prepared to address it at whatever procedural conference it's discussed, and they're not caught off guard by a process that they may not have contemplated. So this is my race through procedural order number 1 and the subsequent procedural orders. Again, you'll get a transcript of this session and a copy of the resources that I've referred to with links. And the most important documents, which I'll refer you to now in case you want to take a look at them while this is fresh in your mind, are the ADRIC arbitration rules schedules, which have the checklist for the first procedural meeting and also a draft procedural order in Appendix R2, R1, and R3. There are other resources on procedural orders, which I will include in the materials. The ICA, the International Council for Commercial Arbitration, has a detailed sample procedural order, often most applicable to international arbitration. And the ICC has a checklist for the first procedural order. So there are lots of precedents out there to give you ideas about things that you should prepare for either as arbitrator or as counsel. My next arbitration matters will be on November the 20th. It is accredited for 1 hour of professionalism content by the Law Society of Ontario, and it relates to the Aroma decision, which everybody has heard about. And what I'm going to focus on is the Court of Appeal decision, which addresses specifically the arbitrator's duty to disclose, and in my view has created more uncertainty about that duty than there was before. And so you may find this of interest. The Supreme Court denied leave to appeal in July of 2025. So what we've got is the Ontario Court of Appeal decision right now, which in my view applies only to Ontario courts. And if you're intrigued by all of this, I hope you'll join me on November the 20th.